today. I spoke then of the old, new anti-Semitism, spoke of the old anti-Semitism as being the discrimination against, denial of, assault upon the rights of Jews to live as equal members in whatever society they inhabit. The new anti-Semitism, as I spoke of then and have repeated since, is a discrimination again, assault upon, denial of the rights of Israel and the Jewish people to live as an equal member of the family of nations. What is common to each form of anti-Semitism, old and new, is discrimination. All that has happened is that it has moved from discrimination against the Jews as individuals to the discrimination against the Jews as a people. But while we had developed at the time of the Stockholm Conference a list of indicators or metrics to identify and thereby allow us to monitor and combat the old anti-Semitism, and ADL had, for example, 11 metrics by which it polled the nature of anti-Semitism. We had not yet developed any new metrics or indicators of anti-Semitism. And what I proposed amongst the group is that we seek to develop such indicators grounded in what I call equality rights in general and anti-discrimination principle and policy in particular. So that would give the whole framing of anti-Semitism as an approach that was part of the larger struggle for human rights in our time. And indeed, it was anchored in some other remarks that I made at that first conference and have repeated since, but whose relevance, I think, regrettably, has intensified over time. And that was that the Holocaust is a paradigm for radical evil, as anti-Semitism is a paradigm for radical hate. And that the intersection of these two paradigms come together in the death camp Auschwitz. This was before we spoke and commemorated in the International Day of Holocaust Remembrance. But I think the words and message remain the same. In a word, 1.3 million people were deported to the death camp Auschwitz. 1.1 million of them were Jews. Let there be no mistake about it. Jews were murdered at Auschwitz because of anti-Semitism. But anti-Semitism did not die at Auschwitz. It remains the bloody canary in the mineshaft of global evil today. And as we've learned only too tragically and have to repeat too many times, that while it begins with Jews, it doesn't end with Jews. But what intensified our work on the IHRA definition, and what is sometimes lost in respect of the whole historiography of appreciating both its development, its challenges, and its impact, is the Durban Conference in 2001. I have to say that as a law professor, when it was first proposed that there was to be a Durban Conference in 1997, I greeted that with great anticipation. This was going to be the first anti-racism conference of the 21st century. It was also to be the first conference on international human rights of the 21st century. And it was to take place in Durban, South Africa, where we had witnessed the dynamics of the anti-apartheid movement. But what happened at Durban, and I say this as somebody who was a member of the Canadian delegation to the Durban Conference, and I might mention parenthetically that I was a member and headed the Canadian delegation to the 4 Stockholm conferences. But what happened at Durban was truly Orwellian, if I can use an oft-abused metaphor. A conference that was supposed to, in fact, commemorate the struggle against racism turned into a conference of racism against Israel and the Jewish people. A conference that was supposed to speak of the promotion and protection of international human rights held Israel out as the metaphor for anti-human rights in our time. And in a word, and as I was to say after Durban, that in a world in which human rights had emerged as a new secular religion of our time, the portrayal of Israel as the meta human rights violator of our time was the portrayal of Israel as the new Antichrist of our time. And with regard to apartheid, I will never forget, and in fact, Durban has had a searing impact on my psyche, I would almost say, as well as on my thinking and advocacy. I will never forget the marches in the streets and the ongoing chanting that the struggle against apartheid in the 20th century required the dismantling of South Africa as an apartheid state, and the struggle against apartheid in the 21st century requires the dismantling of Israel as an apartheid state. And what we witnessed in Durban, and indeed in the regional conference, the last regional conference that was held in Tehran before the actual conference in Durban, but which served as a preparatory manifesto for Durban, was the most scurrilous indictment of Israel and the Jewish people since the Second World War. Very quickly, it was a 7-point indictment, but I'm only going to just excerpt from some of them because some of this is repeated now, but it all began then. One, that occupation is a crime against humanity, a new form of apartheid, a threat to international peace and security. 2, Israel is an apartheid state. 3, Israel is a meta human rights violator. 4, Israel is a perpetrator of international crimes, war crimes, crimes against humanity, genocide. Hence, the right to quote unquote resistance against the quote unquote criminal state. 5, Israel as a Jewish state is quote unquote an original sin established through ethnic cleansing of mandatory Arab Palestine. 6, the reference to Holocaust was in the plural and in lowercase, with Israel as an example of quote unquote a Holocaust against the Arabs. And finally, that, and absurdly so, Zionism was declared to not only be a form of racism, but Zionism itself was declared to be anti-Semitic. This was the kind of framing within which we went into Durban, which in fact found expression in particular at the NGO conference at Durban, which was, and I'll sum it up in one word, as a festival of hate, where all pamphlets, all bulletins, everything was festooned with these indictments. And in fact, every thematic or regional tent, every demonstration, every communication, every information medium was, as I said, festooned with or disseminated with booklets, placards, leaflets, bumper stickers that proclaimed Israel's racism, criminality, and illegality, with the notion of Israel as an apartheid state having, of course, particular resonance in South Africa. And to conclude the impact of Durban, I want to make reference to what happened in the immediate aftermath of Durban, because this is not always appreciated in terms of the impact that it has had then and since. Number one, the Jews were blamed for 9/11, which took place 2 days at the end of the Durban Conference. One can say that while 9/11 overshadowed Durban, Durban foreshadowed 9/11, or as one of my colleagues put it, who was there in Durban after we returned to what was 9/11 2 days later, he said that 9/11 was the Kristallnacht of terror, but Durban was the Mein Kampf. And the immediate impact was, as I said, overshadowed by the 9/11 taking place 2 days after Durban. But there were very quickly the manifestation of the outcomes of the Durban Conference, which we have reminiscences, reflections of, and in fact, resonances of today. Number one, the Jews were blamed for 9/11 in a set of quote unquote new protocols reflective of what was then referred to as an international Jewish conspiracy that was responsible for 9/11. We go right to the present day. We have the international Jewish conspiracy responsible for manufacturing, spreading, profiting from the COVID pandemic. And Dina's Cantor Center has done excellent research on this. Second, in the anti-terrorism debate that took place at the UN in the immediate aftermath of 9/11, Arab states and their supporters opposed any attempt to classify quote unquote resistance as terrorism, appropriated the Durban rhetoric of the delegitimization of Israel, and at the same time, the legitimation of terrorism as quote unquote legitimate resistance against Israel on the other hand. Three, and this is, we speak about the BDS campaign today. Let me tell you what took place in the immediate aftermath of Durban, and you'll see how it was born. A global campaign against Israeli apartheid, quote unquote, was launched in the form of post-Durban calls for boycotts, divestments, and sanctions. But in an astonishing and revelatory development at a pro-divestment conference in Michigan, shortly after the Durban Conference, just weeks after Durban, a resolution which called for a two-state solution, quote, if Israel were to transform itself and become a real democracy, unquote, bad enough, was defeated. But a resolution calling for the dismantling of Israel as a racist apartheid state was adopted weeks after in the University of Michigan. Number four, the first UN Human Rights Commission meeting in the aftermath of Durban, not unlike the road to Durban, sought to single out Israel for differential and discriminatory treatment, with 50% of all the resolutions at that conference, in fact, singling out Israel for discriminatory and selective treatment and opprobrium. Not unlike what we are now witnessing in its successor form in the UN Human Rights Council, which is beginning today as we meet, and where today, as we meet, there's a proposal being discussed for the next Durban Conference to take place on the 20th anniversary of Durban, referencing what happened in Durban, not as I'm referencing it, but as a kind of set of principles and precedents for yet another World Conference against racism, which may yet again turn into a conference of racism against Israel and the Jewish people. And finally, and astonishingly so, there was a convening in December 2001 of the contracting parties to the 1949 Geneva Convention on International Humanitarian Law, which ended up being a particularly egregious and discriminatory act. In other words, for 52 years, for 52 years, the contracting parties had never met, notwithstanding that we had witnessed already by the time of Durban a genocide in the Balkans, the unspeakable and preventable genocide in Rwanda, the killing fields in Sierra Leone, I can go on. The first time that the contracting parties to the Geneva Convention ever came together to put one state in the docket for its massive international violations of human rights and humanitarian law as a criminal state was in the immediate aftermath of Durban. And I have to say, as astonishing as this may sound, that the contracting parties have met twice since. And the only country that has been put in the docket has not been Iran or China or Russia or Syria or any of the other major human rights violations. In each of the three instances, prompted by Durban, that one state was put in the docket for criminal violations of international humanitarian law, that state happened to be Israel. Now, again, let me just say here what needs to sometimes always be said, lest no adverse inferences be drawn. Nothing that I'm saying is intended to suggest that Israel is somehow above the law, or that the Jewish people deserve any special privilege or preference because of the horrors of Jewish history in the Holocaust. Not at all. The problem is not that Israel should seek to be, or that anybody should seek on its behalf that Israel be above the law, but that Israel is being systematically denied equality before the law in the international arena. Not that Israel should respect human rights, which she must, but that the equal rights of Israel deserve equal respect. Not that human rights standards should be applied to Israel, which they must be, but that these standards must be applied equally to everyone else. All these references, which I spoke of at the next Durban Conference the next Stockholm Conference in 2002, which then presaged our drafting with greater intensification of the metrics or indices that then became the IHRA definition. And so what we then had was a series, and I'll go very quickly, of meetings which led to the present adoption of the IHRA definition. But against this entire background, which is so ignored, such that the ahistorical critiques of the IHRA definition today by those who are neither there in its drafting or experienced at Durban, or if they experienced it, were part of those involved in the indictment, always ignore. In 2003 and 2004, and by this time as well, I was a member of the delegations, the Canadian delegations, to both the intergovernmental conferences in Vienna and Berlin. There too, the seeds continued to be laid for the IHRA definition. In 2005, I was then Minister of Justice and worked in 2004 and 2005 with the European Monitoring Center to counter racism and xenophobia, which adopted then the basic metrics which were to take us down on the road to the constituent elements of the adoption of the IHRA definition in 2016. In 2008, just continuing, because moving from the intergovernmental involvement and governmental involvement, in 2008, John Mann, then a Labour MP in the UK, and myself founded the Inter-Parliamentary Coalition to Combat Anti-Semitism. What's important about that is that in 2009 in London and 2010 in Canada, we issued both the London Declaration to Combat Anti-Semitism and the Ottawa Parliamentary Protocol to Combat Anti-Semitism, which effectively contain the language that then became, 6 years later, the IHRA definition on anti-Semitism. So you're seeing here intergovernmental, parliamentary, and then an incredible development which most don't even know about, that came about in 2015 in Canada, in the Canadian Parliament. I had been a delegate with the late Robert Wistridge, one of the greatest, if not the greatest scholar with respect to anti-Semitism, to the first ever United Nations conference on anti-Semitism at that time in 2015. Regrettably, that conference dealt only with the old or traditional anti-Semitism, as I mentioned. It made no reference to the new anti-Semitism at all. But we were all invited to go back to our respective parliaments and, in fact, invite our parliaments to consider the issue, if not adopt the resolution. And so we had what was called a take note debate in the Canadian Parliament. It's for issues of national importance. It lasted 6 hours. All parties contributed to the discussion and debate. And at the end, we adopted unanimously a resolution. All parties adopted a resolution, all parties in the Canadian Parliament, which read as follows, and I'm excerpting it for reasons of time. It began by saying that, quote, "We are alarmed at the global escalation in anti-Semitism." That was in 2015. I don't have to tell you how it's intensified since. Second part, we call upon the Canadian government to make the combating of anti-Semitism a priority in both our domestic and foreign policy. And we referenced the Ottawa Parliamentary Protocol for that purpose. And then came the third part, which is very relevant to the IHRA definition. And it said as follows: criticizing Israel is not anti-Semitic, and saying so is wrong. But singling Israel out for selective opprobrium and indictment, denying Israel's right to exist, or worse, calling for Israel's destruction, is discriminatory and hateful and anti-Semitic, and not saying so is dishonest. Reaffirmed a month later at the Berlin Conference on Anti-Semitism, and which in a year later adopted the IHRA definition on anti-Semitism. So let me just conclude by saying and making the following points. Number one, it's important to appreciate that this is not only the most authoritative, comprehensive, international consensus definition that we have, but that it was adopted after a democratic process involving intergovernmental bodies, governments, parliaments, scholars, and the like. Two, that the Durban Conference, anti-racism conference, which turned into a conference, I said, of racism against Israel and Jews, was the tipping point that led to the intensification of our work to identify metrics for the recognition, monitoring, and combating of anti-Semitism, which culminated in the IHRA definition. Number three, that the process was always anchored in equality rights in general and anti-discrimination principle and policy in particular. That's what underpins the IHRA definition. And I spoke how discrimination is at the heart of both the old and the new anti-Semitism. Number four, because you hear reference to the fact that the IHRA definition, silences speech. I quoted to you from the unanimous resolution of the Canadian Parliament to the contrary, but it not only does not silence speech, it is expressly protective of speech. It is protective of the speech of, for example, Jewish students and their supporters in the campus culture who are themselves disenfranchised, silenced, or bullied, and the like. But it also supports the speech of those who want to be critical of Israel, as I mentioned, or those who want to support Palestinian rights, yet another false shibboleth that it does not allow for the support of Palestinian rights. The only place that the IHRA definition kicks in on is when it crosses the line, into anti-Semitic hostility, discrimination, incitement, and the like. And finally, as I mentioned, the UN Human Rights Council is meeting as we speak. We have to realize that the final dimension, which is not spoken of enough, but my colleagues here on the panel have not only spoken and written about it, is what I would call the laundering of anti-Semitism under universal public values, under the protective cover of the UN, as when the UN General Assembly will adopt some 18 to 20 resolutions annually, singling out one member state of the UN for discriminatory and selective indictment. That state happens to be Israel, but worse, at the same time, giving the major human rights violators exculpatory immunity. Second, the laundering of anti-Semitism under the quote unquote authority of international law. And I gave you some dramatic examples of that in the immediate aftermath of the Durban Conference, but which have continued since. Number three, the laundering of anti-Semitism under the culture of human rights, represented by the UN Human Rights Council, whose mandate requires that states be elected to the Human Rights Council that promote and protect human rights, where in fact the human rights violators now are a majority on the UN Human Rights Council. And Israel not only continues to be singled out selectively, as I mentioned, in resolutions in the immediate aftermath of Durban, but where we have since developed a special article, Article 7, to single out Israel for selective opprobrium and indictment even before the hearing begins. An Alice in Wonderland situation I've witnessed being there at the UN Human Rights Council, where the conviction and sentence are pronounced before any debate begins. And finally, the laundering of anti-Semitism under the struggle against racism. Let's face it, the worst thing you can say about anyone, let alone any state, is to say that they are racist. The very label supplies the indictment. No further proof is required. And if any further proof is required, and so you single out Israel as an apartheid state. And let us always understand that apartheid is defined in international law. And I say this as one who was involved in the anti-apartheid movement for years. Apartheid is defined in international law as a crime against humanity. If you say Israel is an apartheid state, that means it has no right to be. And if that is not enough, you also call it a Nazi state. Therefore, it not only has no right to be, but because it's a Nazi state, the international community has an obligation to see that it has no right to be. So that has been really the trajectory that has taken us from the original hope, Stockholm, to what then took place at Durban, to the present day, and to the meeting today of the UN Human Rights Council discussing the 20th anniversary conference at Durban. Thank you.
Thank you very much, Professor Kotler, for that whole historical background of what led to the ultimate creation and establishment of the IHRA working definition. Professor Porat, why don't you now?
Okay.
That's your remark.
Thank you. Thank you. I'm happy we gave the main floor to Professor Kotler, and I will try to be shorter so that my colleague Ken Marcus will have his time as well. First of all, let me say that today the Cantor Center is engaged in a research on the IHRA definition. The first part of it is mapping where is and by whom and when the IHRA definition adopted. Right now, we almost finished the mapping, though it is still going on because every other day there is some new or another institute, body, country, etc., that adopt it. And the adoption has increased recently during the last recent months, and I see that Professor Marcus agrees with me. We have now crossed the 450, more than 450 states, institutes, councils, local councils, municipalities, universities, and even close to 30 sport clubs and groups. I think that this is why we have more criticism. The more the IHRA definition is catching up and is being adopted, the more you have criticism that is running up and increasing parallel to the increasing in numbers of the adoption of the definition. And this is the background of what we are dealing today, because you have more adoptions and more criticism. Question is, how do you deal with it? Now, let me go back a bit and complement what Professor Kotler said, because there was another line that contributed parallel to what he has described from the Stockholm Conference on that had a part in the creation of the definition. And indeed, it starts in Durban, no doubt. I also had not the pleasure, but the honor of being in Durban, and it was really horrible, horrible. And you could see with your own eyes, not sitting and researching in Tel Aviv University in your safe room, but there outside in the streets and in the conference, you could see how an international decision to deal with racism turns against one country. There were 162 countries at that time in the United Nations. And I asked the president, listen, how come? How did you go from a few years of preparing an international conference on racism to be against Israel? He said, listen, and it took you 2 days only. He said, listen, if we really had gone against racism, and colonial former countries would have been decided upon to pay compensations and retributions, Portugal to Brazil, and Belgium to the Congo, etc., we all go bankrupt. We realized that, we realized the mistake, and the only solution was to pick on Israel. Okay, there you have it from the horse's mouth. Now, I'd like to go in a bit another direction than Professor Kotler so skillfully showed us, because the Durban Conference started not only new anti-Semitism, which is a new phase in the history of anti-Semitism, and it is more in Muslim hands, it is more violent since then, and it is more against Israel. All this is true. But it also enhanced and increased anti-Semitism against Jews per se, not only against Israel. That was not only the central case or the central theme. Violence since Durban against Jews in the world. We are a monitoring body. We monitor anti-Semitism since 1992. It went up. In 2004, it doubled. Violent cases doubled in comparison to 2003. And therefore, there was a need to come up and do something. And so in 2003, I've already written this close to these 4 points that you see today on when anti-Semitism, anti-Zionism is anti-Semitic, but we also put a lot of emphasis on the question of anti-Semitism and classic anti-Semitism. And indeed, while violence went up, and Germany always feels responsible, so in these two violent 2004, you had a major conference in Berlin, which Irvin mentioned, and one of its decisions was, we need, in order to fight anti-Semitism, we need a definition. Okay, and there you have said, quite rightly so, I believe, that this is the most authoritative, etc. definition. It is the only definition that has been compiled and decided upon by a number of scholars, organizations, Jews and also non-Jews, and we all work together. It was coordinated by the AJC, American Jewish Committee, by Rabbi Andy Baker in Washington. We sent materials, we got back, and there was a debate on each word. And this, you have so many, you have a host of definitions. You open every encyclopedia and every lexicon, you have a definition of anti-Semitism, of course. You have a definition of everything. But this is the first one that is not written by a single academic. It is written by a group. It was a major joint effort. And this is where its power lies. It was a joint effort. Okay, why did we call it? And then Professor Kotler already said, 2005 it was first adopted, then it had its history, and re-adopted by the IHRA 2016. So this is first point, that there was another channel, and it led to a joint effort because of the anti-Jewish violence after Durban. Second question, why is it called a working definition? because the point was not to start writing who is an anti-Semite, who is a Jew, what are the motivation of anti-Semites, the history of anti-Semitism, etc. It's a book, it's not a definition. The idea was to have a short, it's a 1.5 pages, not more, to have a short, informative definition that can be of use, that you can work with. What can you do with it? You can identify cases, it can be a basis for complaints, you can train policemen, it can be of help, a point I'll come back to in a minute. It can be of help when there are complaints and there are appeals to courts. So it is a working because it's useful, it's short, and it is to be worked with. Now, I also was in 2016 in Romania, in Bucharest, when there was this big debate in the IHRA to adopt or not to adopt. Okay, as Shakespeare said, to adopt or not to adopt. And most of the countries agreed even before this certain date or certain meeting, but there was a bunch of countries who did not want to join the definition. And you know that in the IHRA, it has to be, a decision has to be unanimous. All countries. If one country does not agree, it ruins the whole maise. Okay, and so these countries were mostly those who were sharp critics of Israel and opposed the 4 points of examples of when anti-Zionism is anti-Semitism. But they did adopt, and not only them, but a whole list of countries that generally criticize sharply. Why did they adopt? Because first of all, they had a responsibility for the Jewish citizens, and because anti-Semitism was on the rise. It was on the rise also at the beginning of the second decade, from 2010 on. And they felt and acknowledged the responsibility for the safety of their Jewish citizens. And this is, I think, to be taken into account, because the IHRA definition, the definition that we call IHRA, it's a convenient way to address it. But as you remember, it started in 2005. The example, there is a definition, a short definition, which we put in a frame. What is anti-Semitism in 2 sentences? And then 11 examples. 7 of them are classical anti-Semitism, denial of the Holocaust, going against Jews, insulting, calling to damage them, to hurt them, etc. And 4 only against Israel because of the new anti-Semitism. So the IHRA definition combines the old classic anti-Semitism and the new one. Now, what is the main criticism today? That it is unclear, it is not specified enough. I told you when it is not specified. If you start specifying and philosophizing, you will end up with a book and not with a definition. But the main argument is that this definition stifles freedom of speech and does not allow criticism of Israel. Now, this really, as you know, first of all, the definition itself says that criticism of Israel is equal to criticism of any other country is not anti-Semitic. Of course it is not. It is anti-Semitic only if it uses anti-Semitic symbols, if you compare us to Nazis, if it's a double standards, etc. We know. But the definition itself has no power to stifle any freedom of speech. Criticism of Israel goes on day and night in Israel itself as well, all over, with and without the definition. The definition does not have any bearing on freedom of speech or freedom of criticizing Israel. This criticism is going on always, and this is the best proof that it does not stifle any freedom of speech. That's it. Now, I would also say that on the one hand, there are calls to have it anchored in law, to make it legal, okay? On the other hand, there are calls to change it, to add to it, to perhaps take off these 4 points that the critics do not like. But I would say the following. First of all, it is not to be changed. Kinderlach, it was such an effort to have this definition that now to start the whole Maise again and debating among everyone in order to change, no. This is the definition. It is already 16 years old. It should go on. I think so. You can add outside the definition examples or whatever, but not change it. It's a big headache, and it's unnecessary. And why I think personally that it does not have to be a law. And not because of the matter of freedom of speech, and not because of the self-determination of this group or other, or the Middle East conflict or whatever. No, because if you make it a law, then it means that everyone who says something about Jews, etc., you will slap him by the hair of his head to the court. It will give the Jewish people a certain status of hunters, of going against everyone, of being offended in a minute. I don't think this will serve us right. And I would say even more than that. Today, the IHRA definition is being used as a tool to help complaints in court laws, in other civil organizations that you complain to, and it is like a soft law. It is like an interpretation of the law. It is a type of non-legal penalization. But it should remain, I think, it should remain not anchored in law, because otherwise it is too strong and too punishing. Like the Jewish people goes against everyone to punishing. The way it is now, it has power, it has impact. I think we should go on as it is and answer the critics the best we can. I will end here with one remark, and this is, interestingly enough, none of the critics refers to the IHRA to say what it is. They say IHRA definition, okay, but they don't say what the IHRA is. Why not? It's the IHRA definition, because it is not convenient for them. The IHRA is a non-Jewish body. Today, it had in 2016 31 members, now it has 33, and there are a few waiting in line. So they don't mention it because it's a non-Jewish body. It is run by ministries of foreign affairs and education. It is not, Israel is just one member as anyone else. And therefore, they don't mention it, because what critics would like to say is that it is pushed by Israel, that it is blackmailed by Israel from countries. Let me say, I said it in the beginning, that close to 30 football and other sport clubs adopted it. Why? What do they have to do with the... Because it is an opening to speak about other evils and about racism. And there is now a new definition of anti-Ziganism going against the gypsies. And there will be other definitions. So it has a broader impact that these football that have racism in the midst can use. So let me end, by saying that the situation as it is, I think it should go on, should be explained, the criticism should be answered. I'd like to thank our Ruth Dar Cohen in the Ministry of Foreign Affairs, who does a great job, and Yogev Karasanti in our diaspora ministry, who does a great job. Jacob Dalal does it in his strategic affairs ministry, and to thank all the scholars and the activists who are working in the field against it, and especially the Cantor Center team and Dr. Giovanni Kerr, who heads the research that we are now doing. We are doing mapping, criticism, implementations, and policy recommendations. It will come out on May, when the IHRA definition will be 5 years old.
Thank you.
Thank you very much.
Thank you very much, Professor Porat, for really explaining how the IHRA definition is really this incredibly valuable educational tool, and for noting that as more and more entities around the globe adopted and recognized the importance and the significance of defining anti-Semitism in order to effectively combat anti-Semitism, it's those who want to continue to engage in anti-Semitism without being labeled or identified as anti-Semitic that are getting increasingly nervous, because the world is beginning to understand what contemporary anti-Semitism really looks like. I now want to turn it over to my friend and colleague, Ken Marcus. Please take it away.
Thank you, Eliza. Erwin and Dina, it is such an honor to join you, and it's been such a pleasure hearing from you. Jacob, we're looking forward to hearing from you in a little bit as well. Eliza, I appreciate it. As I start, I'd like to underscore just a couple things that came out of the prior two remarks. One has to do with the widespread adoption of IHRA and its predecessors, as both Erwin and Dina discussed. One of the pet peeves that I have about the public discussion of the working definition of anti-Semitism is how many times journalists in articles about the IHRA definition refer to it as the controversial working definition of anti-Semitism, certainly in US press accounts. Controversial is often a term that's used with derision by those who don't have arguments against something. They'll simply call it controversial. And yet, as I hope the prior remarks indicate, in a sense, there's nothing that's been less controversial within this area than the IHRA definition. Dina Porat indicated that there are hundreds of bodies that have adopted it. There are now nearly 30 countries that have adopted it, as well as many other institutions. And Erwin listed the various other parliamentary and inter-parliamentary and quasi-parliamentary institutions whose work led up to it. There are now over 50 presidents of major Jewish organizations that have joined in adopting it. You can't find much else that 50 presidents of major Jewish organizations will agree upon other than this. One of them says good morning, and they'll debate, is it morning? What time zone is morning in? Is it good? I don't know. And yet this is extremely widespread. Are there people who disagree? Of course. On any matter of significance, there are going to be some individuals, there are going to be some organizations, there may even be some countries that dissent. And yet this is the only internationally agreed upon definition of anti-Semitism, and it has far more agreement and far more support than any definition of anti-Semitism has ever had. I can't think of another definition of any topic, certainly within the civil rights arena, that has garnered this degree of support and consensus. And I think that that is important in understanding that this is not just something that is being pushed by one party or one ideological sector. It is now increasingly a global standard. Certainly it is as much a global standard as anything can be said to be nowadays. Second thing I would like to flag is Dina's comment that we should not be using the IHRA definition as a law. And I want to say that I agree with her as I understand her remarks, which is to say, I do not believe that all conduct that is anti-Semitic within the meaning of the definition should be prohibited or punished. In fact, certainly I think that that would be a bad thing. In the United States, I think it would also be unconstitutional. I think that there are many different reasons why some activity that is anti-Semitic within the working definition should not be prohibited in any sense. And so that's why I agree that it would be wrong to turn IHRA into a general legal prohibition. On the other hand, it would be equally wrong for courts or agencies to disregard the IHRA definition in matters in which it matters what anti-Semitism means and whether something is anti-Semitic. And so I think I agree with Dina Porat's comment that it should be used as an interpretation. It should be used as an interpretation, and in some places it might be codified as an interpretation. That is to say, it might be important to say, as some legislation has said, and as the President Trump's executive order on combating anti-Semitism said, that under some circumstances, federal agencies should consult this definition in determining whether certain conduct meets its definition. And that has been very important and very impactful. And I'd like to spend a little bit of time explaining just why it has been so important, certainly in the context of the United States and in the context of universities, where we have sadly found, certainly in the United States, that over the last 20 years, we have seen, I'll say, a pause, perhaps a reversal, in what had been a long, steady period of improvement. For many years after the Holocaust, we had seen steady improvement in the anti-Semitism that Jewish students had found on college campuses. But from about the time of the Durban Conference, which Erwin Kotler talked about, since about that time, that is to say, over the last 20 years or so, we have not been able to say that we are still making progress. And in fact, it has been the observation of those of us who follow it that things have actually been going in the wrong direction lately. Not in the sense that anti-Semitism is ubiquitous on American college campuses. There are still many who have positive impressions of Jewish students and Jewish people, but in the sense that the number of incidents have been disturbingly increasing. And some of them, especially in very recent years, have been of a traditional right-wing or white supremacist nature, usually involving pamphlets or materials or electronic communications of a neo-Nazi or white supremacist nature coming from off campus. But they've also included much of the so-called new anti-Semitism. They've also included much of anti-Semitic tropes and memes and language, which has been essentially grafted onto Israel and discussions of Israel and Zionism. And there it has been absolutely critical to understand when something is anti-Semitic and when it is not. This is important in part because there are people who are innocent of anti-Semitism, and we should say so, and we should make it clear, as the IHRA definition does, that not all criticism of Israel is anti-Semitic. But it's also important because we need to demonstrate that anti-Semitism, even when cloaked as criticism of Israel, is a form of hate or bias which should be treated with the same seriousness and the same severity as any other form of hate or bias. A number of years ago, a complaint was filed with an agency that I headed, the U.S. Department of Education's Office for Civil Rights, or OCR, alleging a large pattern of incidents against Jewish students over a number of years. They included Jewish students being called dirty Jews and effing Jews and told to go back to Russia and that Hitler should have finished the job and much else, as well as alleged destruction of a Holocaust memorial, as well as other alleged physical abuse. The case was opened during my tenure during the George W. Bush administration, but after an investigation and after my tenure, my successors closed the case. Now, there were two challenges with the case. The first was the initial question of whether OCR should even be handling anti-Semitism cases. And it was only during my initial tenure at OCR that I signed the orders. This was in 2004, saying that OCR would in fact assert a jurisdiction over anti-Semitism. But the second problem was understanding what is anti-Semitism and what isn't it. Because the agency, after my departure, struggled with this in this particular case and issued a finding in part that this could not be determined to be discrimination. It couldn't be determined to be discrimination on what was then called race and national origin because it was of a political nature. So here we have an agency which had only recently determined that Jews should be given any protection at all, and yet was struggling because some even clear anti-Jewish epithets were confused with being mere political opinion. This is the challenge that we face every day on colleges around the country, even now. Even now, we hear from administrators as well as from faculty and student groups that anti-Zionism is simply a matter of political perspective. And in a sense it is. And of course, Nazism was also a political party. And yet the anti-Zionism that we see on college campuses is laced through with traditional anti-Semitism in ways that have to be understood and grasped. And that is one important reason why we need a definition. During the time that the agency was struggling with this question of what is anti-Semitism and what is not, and should we have a definition or should we not have a definition, and many people were saying we shouldn't have a definition. During that time, the Department of Education contracted with CDC, America's Center for Disease Control, to develop a definition of bullying. The Education Department and CDC agreed with each other that it was important to have an agreed upon definition of what bullying is, when it occurs, and whether efforts to prevent it are successful. And of course, that's why we need, or part of why we need, a definition of anti-Semitism, and yet it was understood to be required to deal with bullying, except when that bullying was bullying of Jewish students. The CDC added at the time that good definitions improve prevention by increasing consistency, that they facilitate comparison among data sets, and that they enable comparison of research on intervention and prevention programs. This at a time when its funding agency, the Department of Education, still was unclear of whether there should be a definition. Indeed, during the period between my first tenure at OCR and my more recent tenure, there were any number of challenges to whether there should be a definition. During this entire period, the US Department of Education had in fact adopted a version of the working definition of anti-Semitism, starting during the Bush-Cheney administration and then continuing through the Obama-Biden administration. There were various forms of the working definition that had been adopted by the State Department, in which were being forcefully used in evaluation of other countries. And we were told, well, yes, well, that's for foreign affairs, but not for domestic affairs, because the State Department has jurisdiction over international relations, not over domestic. But the rejoinder, which took us years of asserting, was that if a particular form of alleged conduct in France or Germany or any other country is anti-Semitic, then it would be equally anti-Semitic if it happens in the United States. And then we were told, well, maybe the definition makes sense when police forces use it, or when it's used in other contexts like the workforce. But in higher education, it's different. Higher education is different because of academic freedom or the importance of public debate concerning matters of political importance. But here again, if something is anti-Semitic when it happens at the workplace, it's going to be anti-Semitic when it happens anywhere else at all, whether it's a school or a hospital or in some other place. Now, the way in which one uses the definition might vary depending on context. It might be whether an anti-Semitic incident should be criticized or punished or prohibited would depend on a variety of factors that might be different based on the context in which it happens. And yet the meaning of the incident and whether it's anti-Semitic or not should not vary depending on where or when it happens. We were told then, and Dina Perrott mentioned that speech is one of the arguments, but there are any number of different changing arguments that have been made, not always particularly sensible, and yet one after another has to be swatted down. We were told, for instance, that there should not be definitions used for particular offenses under Title VI. It should be case by case. And yet for many years, OCR, like other agencies, has used set definitions for sexual harassment. And in fact, over the last few years has made a significant priority over defining and redefining what is and is not sexual harassment. And it's important to have definitions in civil rights enforcement, particularly for large multi-office agencies, in order to have consistency of enforcement, as well as predictability and transparency, which are very basic rule of law values. We have been told that adopting a definition of anti-Semitism would open the floodgates, and soon we would have definitions of everything, as if that were a problem. Well, the fact is we haven't had a storm of definitions coming through, but it seems to me that if additional definitions of civil rights issues were properly formed and developed, perhaps using a process along the lines that Erwin Kotler had described earlier, a democratic process that is considered and reasonable, that wouldn't necessarily be a bad thing either. Dina spoke a little bit about the issue of speech, and I'd like to, as did Erwin, and I'd like to return to it as well. Erwin argued that the working definition, in fact, supports speech, and I want to reiterate that. It seems that every week we get another complaint about the denial of Jewish speech, especially Jewish pro-Israel speech on one campus or another. Sometimes it involves pro-Israel speakers being disinvited or heckled. Sometimes it involves Jewish students being told that they cannot join a particular organization, usually a progressive organization, because of their Zionist commitments, or it might be a Jewish organization being told that it can't join with other Jewish organizations because of their principles. In no other case is a minority group told that their participation in university life is conditioned upon their disavowal of principles that their group holds dear, and yet this happens on a very regular basis. If the IHRA definition is important in the US university context, one of its most vital contributions is that it should be used to enable Jewish and pro-Israel students to express their identity in a more free and forthright manner. And in this sense, it certainly does advance freedom of speech. Let me also say quickly that it is conceivable that it could be misused in a way that would interfere with speech. And that is also true of any other definition or standard. Any civil rights standard that is of any force or usefulness could be used to suppress speech. But I think that the IHRA definition does have certain limitations or tools or restrictions that can help to avoid that. For instance, it is useful and important that the definition says criticism of Israel similar to that leveled against any other country cannot be regarded as anti-Semitic. It is important that the examples, the guiding examples of anti-Semitism are expressed, quote, taking into account the overall context. That is to say, we're told that not everything that fits within one of the examples will necessarily be anti-Semitic. One has to consider the context as well. But beyond that, the various instruments by which it has been used within law all have additional limiting principles. The executive order on anti-Semitism explicitly indicates that the working definition should not be used in a way that limits speech. And in addition, it has a very narrow limitation that it should be used in ways that can identify whether conduct which is alleged to be anti-Semitic is in fact motivated by anti-Semitism. In other words, it does not prohibit all anti-Semitic speech, any anti-Semitic speech, or even all anti-Semitic conduct. It provides a tool for discerning conduct. So in all of these ways, I would say that when properly utilized, as for instance in the executive order, the working definition of anti-Semitism can address what had been a paralyzing problem for civil rights enforcement, and it can do it in a way that will increase speech rather than decreasing it.
Thank you very much, Ken. I want to give now Jacob Dalal a chance to make some brief remarks. Jacob is the Director of Academic Affairs at Israel's Ministry of Strategic Affairs, and in that capacity, he leads the ministry's effort in combating anti-Semitic hate speech online. Jacob, we've received also a whole slew of questions, and so I'm wondering if maybe in your remarks you can also address just a couple of them. One question that people have asked is, why is this called a working definition? And then also specifically when it comes to trying to address the division in the Jewish community over this definition, how do you respond to members of the Jewish community that appear to be opposed to using and utilizing and the formal adoption of this definition? So, Jacob.
I thank you very much, and I'm really very pleased to be here and to see the real interest in this. I think this is turning into a mini symposium, which is great. I think that I just want to say generally that with the increased traction in adoption, especially in the last year, and we're speaking beyond governments. We're talking about civil society. We're talking about NGOs, Jewish NGOs, but non-Jewish NGOs, religious institutions, soccer clubs, universities. This shows that the IHRA definition is really bringing itself to a new level. I want to thank sort of my colleagues at the Foreign Ministry and Ministry of Diaspora Affairs who spearheaded the effort originally to make traction on this diplomatically, but now it's moving to another sphere, and a very important sphere of civil society. I want to note also the European Commission just put out a handbook on how the practical use of the working definition, which is excellent in terms of, and I refer particularly to the good practice checklist at the end of that handbook, which shows how you can actually talk about implementing this on a practical level with interlocutors in civil society and in government in a very sort of practical manner. And this is the European Commission that released this, cannot be accused of being an interested party. Also, the Cantor Center's upcoming research with their database on all the institutions that have adopted it, very, very important and helpful. And this sort of leads to, as you were mentioning, Lisa, sort of a bit of a backlash. And we've seen that in two spheres: in the academic sphere, where we've had a number, over half a dozen letters, a total of close to 2,000 signatories of academics against the definition in one form or another in the last year alone. And that's why, as Ken mentioned, it's very important to discuss this, to open this for discussion in the academic sphere, to talk about anti-Zionism and anti-Semitism. Is there an overlap? Isn't there an overlap? This is sort of focusing the discussion around the issues that the IHRA definition brings out. This also may help in discussion with our Jewish brethren and others who are, I would guess I could call them in the anti-Israel community, and they too, specifically in Canada, the US, UK, and Germany, have increased significantly their opposition to it, again, around the issue of new anti-Semitism. But new anti-Semitism is something that really bears discussion, and now is a great time to do it. So I think that that's one thing that we have to do, to start open a academic and an intellectual discussion around it. And the second thing to do is to use the definition properly, not to get carried away, to use it accurately and effectively. And we have here excellent experts who can help organizations that this is their profession. So I reach out to the audience and say, as you use it use it appropriately. And if you're not sure, ask. There are plenty of experts here and elsewhere. And in that context, I would say a verb, as opposed to the verb adopt, in some cases, it might be better used to use a verb like integrate or use. It's always very helpful, as you, Lisa, mentioned, to note the educational value of the educational usefulness of the definition. And I love what Professor Porat said about soft law. In the same way that soft power works in tandem with, but is fundamentally different than hard power, the IHRA definition is there to alongside, but fundamentally different in its being a non-legally binding definition than actual law. And finally, I just want to point out that this converges with the work that we've been doing at our ministry. Again, it's in the last half a year against online hate speech, along with my colleagues in the Ministry of Diaspora Affairs and the Foreign Ministry. We presented a outline for online a policy for an Israeli government policy to combat online anti-Semitism. And in relation to the IHRA definition, we called for the integration of the IHRA definition in the policy of the social media networks. And as a first step, we believe that they should consider a wider use of labeling and refer to the IHRA definition formally, both in labels and in their policy. So to conclude, I want to thank not only the host, but everyone in the audience. And I see the audience has not dwindled. So that's also a compliment to everyone here. And to use the speakers and their resources in navigating this effort, which is gaining momentum in the most effective possible way. Thank you.
Thank you, Jacob. I realize also Professor Cutler has to go, and we have a hard stop at 12:30. I want to give the panelists, if there are any of Professor Cutler or Ken or Professor Parad, if you have a final word about IHRA that you'd like our audience to know after this presentation. If you have further questions, I will say, because we have gotten questions that we probably won't be able to get to, you should feel free to forward them to us at the Brandeis Center at info@brandeiscenter.com, and I will try to continue this conversation by forwarding them on to some of our panelists so that we can continue to engage in this dialogue. And I thank everyone. Are there any of the panelists who want to add one more comment in closing?
May I?
Sure.
Okay. I'd like to join what Ken, my colleague Ken Marcus said, and Jacob Dalal said. And this is that not only, and with this to finish, you're right, there is just 1 minute or two. It's not only that the definition does not stifle freedom of speech or any criticism, but that they go on and on, but that it raised a lot of conversations and a lot of discussions and a lot of dealings with matters of principle in the universities in the United States, as Ken has shown, in inter-parliamentary committees, as Professor Kotler has shown. It has the debate around it opens questions, raises problems, not only around Jews as a minority, around minorities in general, around rights of minorities, against how you deal with people who are different in a way. It is a tool that has opened not only to understand anti-Semitism, but to understand other related evils. And I think that Jacob asked or recommended that people come to, we are not such experts. We are learning. We ourselves are learning in the process of this going on. We are learning every day what is going on. So I'd like to thank everyone and to say we should continue the efforts.
Absolutely. Thank you very much to all the panelists, to Professor Cutler, to Professor Parat, to Professor Ken Marcus, my friend, colleague, to Jacob Dalal. This has been a wonderful, educational, engaging discussion. And you're absolutely right. This is just the beginning. The whole idea of the IHRA definition is to help educate and inform our society so that we can better address the problem of anti-Semitism today. Thank you very much for joining us. We look forward to seeing you at future events.